the Divorce Education Series presented by Findling Law. And in this webinar, we're going to discuss planning for divorce. If you're thinking about divorce, what is it that you need to know? First, that you have choices. You really have three choices: to do nothing, to work on the nature of the problem, or to divorce or legal separation. I've written a pamphlet precisely on these three choices, and I encourage you to download it from thedivorceguy.com. Doing nothing, you already know how that works. You're living it right now. Working on the nature of the problem means doing something about it, going to therapy, seeking a counselor. But remember, it takes two people to be committed to work on the nature of the problem. It can be successful. Finally, divorce or legal separation. Experience has showed me that all three of these decisions are good decisions depending upon the person and the circumstance. For the remainder of this webinar, we're going to talk about divorce or legal separation. What is it that you need to know? How do you plan accordingly? First, does it matter who files first? This, of course, would be in a divorce situation. And the answer is surprisingly, generally, no, it doesn't matter. But when does it matter? When can it make a difference who files first? Well, it can make a difference if you're worried about one party dissolving the marital estate. Maybe you're fearful that he or she is going to liquidate her 401k or the bank account. Then filing first, you can get a restraining order regarding property transfer and preservation of the marital estate, essentially making it a violation of a court's order to do so. It also could matter who files first if you're worried about maybe the case being transferred to another state, or a party leaving with the minor children to go to Florida. By filing first, you can be certain that the case is going to remain in Michigan, in the county in which you filed. And of course, emotionally, it always matters. Well, in many circumstances, it matters. Are you the plaintiff? Are you proactive in life, or are you being reactive in life? For many people, filing first makes them believe and feel that they're doing something about their life, that they're taking control of their life. And this is a very important notion to take into consideration, because besides being a legal aspect to the law, there's also an emotional aspect, especially as it pertains. So there are certain rules or guidelines or considerations I want to talk about if you're the dependent spouse, and then of course if you're the primary wage earner. As the dependent spouse, you really want to be a detective. You want to know as much information about the marital estate as possible. That is, what are your monthly expenses? Copy everything. If mail comes in and it's a statement, whether it's a tax return, retirement statement, mortgage, credit card statements, make copies of everything that you can. The more information that you have, the more powerful you become, because you understand the nature and the extent of the estate. And the other thing I think that a dependent spouse needs to do, and in some circumstance even the primary wage earner, if you have that certain something that you really want and you're concerned about it, put it away for safekeeping. Maybe put it with a relative. Provided that there is not a court order to the contrary, that if someone's filed first and there's an order that says you can't do that, it's always a good idea to put away those special items, maybe grandma's brooch, whatever it is. Because when you have a highly emotional case like a divorce, oftentimes things come up missing. It's also a good idea to video contents of the home. Maybe do a walkthrough with your phone and sort of talk about what things are. You may wake up one day to find out that your spouse is gone and half the stuff is missing, but you just can't remember what half that stuff is. The key here, once again, by being a detective, is understanding your assets and your liabilities. One of the first things a lawyer is going to do for you, if a lawyer gets involved in a divorce case, is conduct discovery to help you understand this. But the more you know coming in, the less expensive your divorce is, the less work, and the more powerful you are at the beginning of the case. Saving cash is always important. Remember, if you are getting divorced and you're a dependent spouse, ask yourself this question: if my husband or wife were to leave right now and close the bank accounts, what would I have? How am I going to make it that 3, 4, or 5 weeks before a lawyer can get money flowing again? How can I afford to pay for a lawyer or to pay my rent? Putting cash away is always a good idea when you're the dependent spouse in case of emergencies. Make important purchases. What I mean by that is that if you have a lawnmower that's breaking and the lawn's 8 inches tall and your spouse said that he or she was going to make that purchase that lawnmower and just hasn't, go ahead and make it. Buy that lawnmower. And the same thing goes with maybe health procedures. If you need something and you've been holding off on that, well, do it now before you file. Why? Because oftentimes money is in short supply once a divorce. All right, the primary wage earner, there's different rules as you can imagine. First, you want to keep as much information, sort of the opposite, be the anti-detective, right? You want to keep as much information personal about the nature and the extent of your estate. Sure, we're going to share it when necessary, but you don't want to give it all away until you've consulted with your lawyer. You've sat down with that consultation and discussed a strategy and goal about how you want to proceed. Don't transfer assets. Michigan law is really specific as it relates to whose name is an asset in. In many instances, if an asset is solely in one party's name, it may not be divisible in the divorce case. But once you maybe add your spouse to an account or an inheritance, that can move that property from separate to marital, and now you have to give your spouse a share of it. So do not commingle assets. Keep as many assets in your name as possible. Of course, if you're due for a bonus, defer income until after the divorce, especially if you have spousal support or child support considerations. Same thing goes if you're considering a divorce. Once that pension vests, it's divisible. If it hasn't vested yet, then it's not divisible. So you may want to, from a timing standpoint, take into account, do I really want to stick around for another 2 years or 3 years and then give her half of that retirement or half of that pension? Right now it is invested. Maybe now is the right time for you to make the decision. And it's always important to save cash for the same reasons we talked about with the dependent spouse. Now, when I talk about managing debt, debt can sometimes be a good thing. When we divide a marital estate, we divide the assets and the liabilities. So if you're the type of individual that pays off your debts on a monthly basis, it may not be a good idea if you are, in fact, planning for divorce. Because the more debt that you have, all of a sudden in the property settlement, your spouse is now required to share in those debts. On the other hand, it may be important, and this is one of those things where you really want to sit down and have a consultation with your lawyer, and your lawyer will really key his advice or her advice into what's right for you under your circumstance. But many people say, I pay off my credit cards on a monthly basis, or I've taken a loan from my 401k and paid off all the debt. That is not a good idea. Debt can be a very good thing in divorce planning. All right, some don'ts. All right, don't make a major purchase. Just because you're getting divorced, I don't want you to go out and buy that home right now. Wait until the divorce is done or the separate maintenance is done. Why? Because you're not certain what the nature and the extent of your estate's going to be at the end of the day, what your cash flow is going to be, what your support's going to be. Wait. If you need to get out of the house, and generally we recommend that you don't leave the house during a divorce, but if you need to, rent, okay, maybe a 6-month rent, a 6-month lease, but don't make major purchases. Don't quit work. There is this theory of this unexercised ability to earn or an underexercised ability to earn. If you voluntarily reduce your income, for the sole purpose of trying to avoid support, courts will often impute your income back to that level. And you may no longer have access to that job, but now you have an obligation equal to what you were making beforehand. So it's never a good idea to quit work. Of course, don't have an affair. This is for both the primary wage earner and the dependent spouse. Why? Because fault can make a difference in property division in Michigan. Fault can play a role in how we divide debts. Fault can play a role in a child custody determination. Fault can play a role in alimony. In short, just because we're a no-fault divorce state doesn't mean that fault does not matter when it comes to your assets, your liabilities, your children, and your support. It can make a difference. In addition, even if none of those are concerns of yours, having an affair, extramarital sexual contact or an affair, can screw up a settlement. It really can make it difficult. If your spouse hears, sees, whatever, that you're with so-and-so or such and such, and you have this simple divorce case, all of a sudden you've made it really complicated. So my advice is this: don't do it. Don't have the affair. If you are having the affair, use discretion. Don't tell a soul. Rule number 1, don't do it. Rule number 2, if you're doing it, please use discretion. It really can complicate your case. And don't pay off separate debts. If your wife has a debt or your husband has a debt that predates the marriage, and you're going through trying to clean up your estate and so forth, don't pay off those debts for the same reason that we talked about before. Debts can be good on either side of the equation, whether you're the primary wage earner or the dependent spouse. Don't move out of the house. Why do lawyers say this? Well, for a number of reasons. One, if you move out of the house, you got to figure out where you're going to live and how much is it going to cost for you to live. And you may not know the answer to what your cash flow is going to be. Second, if you move out of the house, this is like a major purchase. It's a major decision. If you move out of the house and there's minor children and you want custody, that could create an established custodial environment and compromise a custody case. Now, in many instances, clients come to me during a consultation and I tell them, it's all right, move out of the house. But that's very specific. We want to talk with you, counsel you, and help you prior to you making that decision. But for purposes of a webinar, let's make it a rule. Don't move out of the house without first consulting with your lawyer. All right, it's inevitable that you're going to have questions, and I encourage you to call for a free confidential consultation. We want to help you manage your situation. I know it's a struggle. Life can be difficult. I provided you my email address. You can also visit me at thedivorceguy.com or call me toll free at 877-968-7347. Thank you very much and best of luck.